Okay, our next presenter is Mr. Ken Melson. Ken has a really long bio, so I'll try to get through it, but we have a couple of extra minutes, and he's the only thing between you and lunch, so I'm sure he'll be nice enough to make it short and sweet. So Ken is a professional lecturer in law at the George Washington University Law School. For more than 40 years, he has taught law and forensic science courses at both the law school and the Department of Forensic Sciences. In addition to teaching, Mr. Melson works in the General Counsel's office at the Office of the Inspector General of the U.S. Postal Service. Prior to that position, Mr. Melson was the senior advisor on forensic science in the Office of Legal Policy at the U.S. Department of Justice from August of 2011 to September of 2012. He has also served as the co-chair of the Subcommittee on Forensic Science, Committee on Science of the National Science and Technology Council within the Executive Office of the President. In April of 2009, he was named as acting director of the Bureau of the Alcohol, Tobacco, Firearms, and Explosives by President Barack Obama, where he served until August of 2011. Prior to his service at the ATF, Mr. Melson was appointed by the Attorney General as the Director of the Executive Office of U.S. Attorneys, where his responsibilities included administrative oversight of the 94 U.S. Attorneys' offices and being a liaison among the U.S. attorneys and other federal agencies and the Department of Justice components. After serving as a prosecutor in Arlington County, Virginia, for almost 10 years, Mr. Melson joined the U.S. Attorney's Office for the Eastern District of Virginia in 1983, becoming the first assistant U.S. attorney in 1986, a post he has held to his departure in 2007. Mr. Melson is a graduate of the National Law Center at the George Washington University. He's a past president of the American Academy of Forensic Sciences, as well as a distinguished fellow. Mr. Melson is also a past chair of the Council of Scientific Society Presidents, and for more than 15 years, Mr. Melson represented the Department of Justice as a member of the American Society of Crime Laboratory Directors Laboratory Accreditation Board. He currently serves on the editorial board of the Journal of Forensic Sciences and on the ethics committee of the AAFS. And he has published in the scientific literature, both in text and legal journals. So with that, I will turn the mic over to Mr. Melson, and he has about 30 minutes, 40 minutes.
30 minutes, and I'll save 29 for questions. Thank you, and after all that, I flunked the statistics test. It really makes me feel well. Thanks, Melissa, for setting me up before coming up here. I want to thank NIST and DOJ and the other supporting associations for inviting me here. It's a real privilege to talk here. I want to, as a disclaimer, tell you that NIJ has not funded this presentation. Thanks a lot, Jerry. Appreciate it. I'll remember that. And I also noticed that I was on the tail end of this morning's presentation, which confirms my hypothesis that an attorney is the last person you want to hear from. But unfortunately, I have to let you know that you're going to have to work with attorneys and judges in trying to get the quantitative analyses admitted into court. One of the things that we have to remember is that, there it is again. There's Peter's eyeball. It's Peeping Tom, or should we call it a Peeping Peter? But whatever it is, it's to remind you that we're not only looking forward to where we're going in question document examination, but others are watching you as well. And it's primarily the courts and the lawyers, because they want to know what you're doing so they know how to go forward in their legal decisions. So I want to talk to you about the quantitative analysis and the likelihood, the qualitative likelihood that that type of evidence, quantitative evidence, will be admitted in court. Now, we all remember the NAS report, and you've heard too often already here that they concluded that there was a lot of subjectivity in various disciplines, and there was a lot of weak scientific bases in a lot of disciplines. And with respect to question document examination, as you heard earlier yesterday, the committee agreed that there may be some value with respect to question document examination. Now, that's not a very high praise, and probably if it's only worth some value, it probably would not pass Rule 403, which says that the probative value has to outweigh the prejudicial value. But the part that I took real objection to in the National Academy of Sciences report was Chapter 5, which talked about these, because I think they had under-researched the issues and overvalued their conclusions. Because you'll also remember now, Ted Burks in his introduction yesterday said that the research is proving what you've all been saying for years, and that's important. And as we look at the cases recently, you will see that since 1993, when Daubert came out, and question document examination kind of took a dive where they weren't allowing experts to express an opinion, I think you're back up on top. And we see that in cases like the case from the D.C. Court of Appeals. And that was a case in which Kirsten Jackson testified in, I believe, the Mornon case, in which it was a Fry hearing. And they were very, very complimentary of handwriting, and it was admitted. The same thing in Pettis U.S., which is another case. And those cases show that question document examination is being admitted regularly. I'd also like to point out the courage that Jane Lewis had. Where are you, Jane? There, you're right in front of me. She challenged the vice president of the American Academy of Forensic Sciences, who's a member of the jurisprudence section and a prominent defense attorney, about a comment she made disparaging, or perhaps you could interpret it as disparaging, question document examination. And as a result of that, they wrote a second letter in the jurisprudence section part of the Academy News in September, I believe, of last year, where she said this, along with the chair of the jurisprudence section. Question documents is a forensic scientific field of tremendous importance and value to the justice system. We do not support the view that handwriting comparison examination is a statistically unproven or invalid technique. So as I say, I think you've come a long way since the NAS report. So I want to talk a little bit about the interpretive conclusions. Many of the courts say you have to have more than just presenting the evidence, because that evidence wouldn't be meaningful to the jury in most cases if you just say these are the characteristics that I compared and they're similar or they match or whatever terms you use. You have to use some qualitative or quantitative expression in order to make your evidence meaningful to the court. Even though in question document examination, the courts for a while were saying you can't give an opinion. Actually, that was good in many cases, particularly if lay people have more confidence in their own analysis of handwriting. And I've had cases like that where they couldn't express an opinion, and the jury thought there was an absolute match, without question. It was perfect. It was beautiful. So why do we go any further? Because the law is going to make us go further, I think. So the other thing the NAS report said was that DNA is the gold standard. And so everybody now is expecting statistics from their field of discipline. And that's hard in some cases, easier than others, but right now, about the only forensic discipline that's giving good statistics is DNA. So there has to be, to continue to go on this path forward, as the NAS said, in order to create a better foundation for our opinions, have to go towards some sort of statistical analysis and in a quantitative manner instead of a qualitative manner. The NAS report, when it talked about these disciplines, cited Boziak, who you may be familiar with. He's the footwear impression expert. They cited him for having these characteristics of a quantitative analysis if you're trying to determine a degree of uniqueness. And by the way, the citations to these things are on the last couple pages. And also, this is a new PowerPoint, not the one that you have now. I added another case or two. Because, you know, we can never stop as lawyers. We always got to add something. We always have to have the last word. One of the things that was a problem during the early years is that there was a big hesitancy to have a trial by mathematics. And that was because they were afraid that the overwhelming odds that were being presented to the jury would sway them too much, that they would be prejudiced by that, and that there was no real foundation for the statistics to begin with. So they were very concerned about that until they got to DNA, when DNA began to provide statistics, and you had the DNA wars. And then the court started out saying, well, we can't have DNA without the statistics. And then they fought over the statistics, and after the DNA wars, they now accept the statistics because it's been proven that the community generally accepts the methodology for determining those statistics. Question document examination has used statistics in the past. And here are just a couple examples, probably examples of what we all want to stay away from in any statistical analysis in any discipline. Excuse me. So, for instance, going way back to the Dreyfus affair, they had handwriting in that famous letter there. And although I didn't know what the odds were or couldn't find it, it was described as being an amazing frequency in which the letters appeared in a string of letters that you see up here on the screen. And who was that expert? Someone you probably recognize. You recognize him? Bertillon. Exactly, Peter. And you know his history and impact on the forensic science community. But he was part of the travesty of the Dreyfus affair. Then there are other cases like the famous Howland-Will case, where there was also a very high statistical correlation between the known and the unknown. In fact, it was, and I'm not even sure how big this number is, 1 to 2,666 million of millions of times. All right? And that was never contested in court. All right? They just accepted it. Then you had the People v. Risley case, which was an interesting case. It was typewriting and not handwriting. But they determined the probability of the certain characteristics in the typewriting between the questioned and the several known typewriters that they got from the office of the defendant. And that was 1 in 4,000 million, which was, again, a pretty good statistical basis, even though the testimony was not based on any observed data, and the witness was not an expert in comparing typewriting. He was a professor. Well, there's nothing wrong with professors, but in this case, he was a professor of mathematics, and the whole testimony the court concluded was hypothetical and speculative. So, let's get to some more recent cases, far removed from Dreyfus. So what do a black man with a beard and a mustache have to do with a blonde white woman and a 1968 Lincoln? Pardon? Collins. Okay, so you know Collins, all right? And in that case, as you recall, they were having a very difficult time identifying the two defendants, who were a black man with a beard at the time and a mustache, and a white woman with blonde hair and a partly yellow Lincoln. So they created these characteristics right here, and along with that, determined the individual frequencies of each characteristic occurring, and then multiplied it together and came up with 1 chance in 12 million that those two people would not be the individuals in the courtroom. All right, now, it probably would be 1 in 120 millions if the man had a beard like Peter's, because his alone, the frequency is 1 in a million. So we go from there and look at some of the lessons from Collins. And this really is a watershed case. It's quoted a lot of times, but it has some very basic lessons in it that you all have kind of identified already, and that is that there's got to be an adequate foundation for the stats to begin with. In this case, the record was pretty much devoid of any of that. The sample has to be determinable. They didn't have a determinable sample in that city or that county or that state from which to draw from. There must be an adequate proof of statistical independence, and they didn't have that. I mean, how many people have beards and no mustaches? We know we have a lot of people with mustaches and no beards. So what's the relation or the independence between those two, and things such as that. And I'm not going to mention everything here because we do have a time issue here. All right, so another lesson is don't be inveigled by the prosecutor, because in that case, the prosecutor was really the one giving the expert hypothetical individual frequencies of what he was multiplying in the product rule. And he was just getting up there and doing the math without any foundation for that. So don't be pressed by the prosecutor or the defense to establish a probability based upon numbers that aren't in the record, that have not been proven in the trial. All right. So the Collins ended up saying that mathematics, a veritable sorcerer in our computerized society, while assisting the trier of fact in the search for truth, must not cast a spell over him. And they reversed the case because the defendant was convicted based upon the odds. All right, so is it always an admissibility issue? Sometimes it goes to the weight. And I know you hear this all the time between admissibility and weight, but it really is a way around by arguing that it goes to the weight. So in the Coolidge case, they had an issue of finding particles of dirt in the suspect's car and particles of dirt on the victim. And they compared the two and determined the the frequency was 1 in 10, multiplied that by 27 different sets, and came up to 1 in 10 to the 27th power. All right, so the court here in Coolidge said that the evidence was properly received, and it went to the weight of the evidence. And even the fact that there was some concern about the wholly independent nature of each of the particles of dirt that was collected from each side, it still went to the weight and not to the admissibility. So oftentimes you're going to see an argument that allows evidence into court even though there is not a fully developed foundation for it. Carlson's another case of interest, and that dealt with microscopic hair comparison. And we all know about the frailties of microscopic hair comparison in the past. But in this particular case, there was a comparison done by an examiner who testified to the similarity between whatever number of characteristics they looked at in between the known and the unknown hair. But Gaudet also got up on the stand, Barry Gaudet, who was the RMCP serologist from Canada, and he testified, as you see on the screen, to those statistics. Of course, many people testified to those statistics, even though his studies were based upon a particular race and a particular part of the body, but it didn't seem to matter to other people when they threw around his statistics in their particular case. So the court said you can have the hair comparison come in where the examiner testified to the similarities, but you can't have the testimony about the statistical data because there was no empirical scientific data for it. So you obviously have to have that. So they were concerned with the exaggerated effect of these statistics with respect to individuals who are on the jury and hear these statistics. And I wanted to also refer to one other case that was not in the original presentation, but I want to make sure that you are aware of it, and that's the State versus Garrison case. And it's now on the end of the presentation. It's 585 Pacific 2nd, 563. It's an Arizona case where a past president, actually, of the American Academy of Forensic Sciences, who is a dentist, testified to a bite mark back in 1978, and he testified that the probability that this was the defendant's bite mark was 8 in 1 million. All right, 8 in 1 million. So the dissenting judge in that case, because the majority said that was okay to say, because he relied upon the Journal of Forensic Science and 2 other books, the dissent said absolutely no way, and went back and actually looked at those journal articles and looked at those books and found that only one book referred to statistics at all, and that referred to 8 in 100,000, not an 8 in 1 million. So it's another example of what they did with Gaudet's studies, is that they use these numbers, they don't use them correctly, and they're not studies that apply in their particular case. So the concern is that you use these stats without the proper foundation, the jury takes too much importance or stakes too much importance in those. There's also the prosecutor's fallacy. So when you testify to a quantitative analysis, you've got to make sure you don't do the prosecution fallacy or the defense fallacy. In other words, you don't testify that this statistic means that the defendant did it, he's guilty because it's 1 in a billion, nor does it mean it's his DNA because it's 1 in a billion. You give the statistics and the jury decides the meaning of that. So here's an example of where the appellate court found no error in the use of the prosecutor's fallacy because the expert testified properly, and that was simply to the statistical basis and the probability. Rule 403 is the rule that I mentioned before about the prejudicial value over the probative value, and that's why you have to have a strong foundational base. And one thing I think the courts will look at with respect to forensic document examination in each case when they look at the quantitative analysis is how strong is the underlying handwriting science to begin with. What is your foundational science? If your underlying science isn't all that reliable in the eye of the court, they're not going to be so impressed with your statistical analysis. So you're always going to have to take both of those hand in hand and show your scientific basis, then show the basis for the statistics. So I mentioned that was about the DNA. Laboratory error. There are some arguments by some defense attorneys that you ought to put in laboratory error as part of your probability statistics. And this has been used in a couple cases. The courts so far have rejected it pretty overwhelmingly, that there are two different things. They are two different things and shouldn't be commingled. In fact, the NRC said the same thing back in their first report on DNA back in 1992, that you don't put both of these, the error rate and the probability rate, together. All right, the admissibility issues are Fry and Daubert, of course, and I'm not going to go through each of these. Let me say with respect to Fry that, as I said earlier, and I think I cited the wrong case that Kirsten was in, but the D.C. Case was a very strong Fry case. It was the D.C. public defender is a very robust, aggressive public defender's office, and they've been going after question documents, fingerprints, firearms identification, and this court came out very strongly in the Fry case. And one of the things it said was that Denbaugh and all his professorial friends are not part of the relevant scientific community for purposes of determining general acceptance. All right. Now, when you get your quantitative analysis game together and go to court, you're going to have to go through an admissibility test like you do for the admission of your handwriting testimony, basically, as well. So when you look at Daubert, you have to look at all those considerations with respect to trying to get your testimony, your conclusions into evidence. One of the things you talk about is peer review, and make sure, and I know you do this, that you have these articles and projects peer-reviewed articles. Because I saw in a number of cases where the court's actually saying that these stats or these numbers or this, the basis of this particular element of the science is peer-reviewed and in the Journal of Forensic Science. So it's a good journal, and the other journals are as well. But they're beginning to recognize now that these scientific peer-reviewed journals, apart from how they're criticized by some of the critics of forensic science, are journals in which there is adequate and valuable peer review. In addition to Daubert, remember you have the Federal Rule of Evidence 702, that it must be based upon sufficient facts or data. I mean, this is pretty obvious. It was written after Daubert, so it incorporates some of that. So here are your admissibility challenges. for quantitative assessment. And we've talked about some of this, the foundational availability of validity of handwriting. You've got to understand that you have to present that. A determinable and scientifically defensible source population. Now, I put down their population substructure only because that was a big issue in DNA, but also it may be an issue here with respect to maybe the ethnic background of the individual, where he came from, maybe race, maybe whether it's a foreign language. So you may have a substructure issue as well with respect to handwriting. And source selection. They're going to contest how you are selecting your particular characteristics that you look at and measure. The independence we've talked about, the validity of the frequency determinations, and the capability of computerized handwriting recognition and identification. And I see the end note because there I cite a couple cases where Dr. Sharari's experiments have been considered and considered well by the courts, along with FISH and the U.S. Secret Service databases, your database. The court had looked at that for purposes of validating the basis of handwriting. So they're already a step there. And if they're looking at that to show that the measurement in the computerized process is probably 98% accurate, they're going to be adopting that and relying on that as well when you're doing the statistical bases for it all. The maintenance of standards is very important. It's like anything else you do in the lab. You ought to have a protocol and standards that you follow and do it in every case. And if you're accredited, you will be doing that in any event. There was an issue in a number of these cases trying to keep the experts' testimony about the statistical basis out of evidence based upon the fact that they didn't have any idea how the statistics were calculated. So these are a couple cases in DNA cases where the person said, I don't know, I take the numbers and I stick it in the computer, it spits out the stats, and here it is. Well, that wasn't real impressive to the court. And those people have a hard time getting the court to allow them to testify to the statistical basis of it. So not only do you have to have your community know how these stats are created in a quantitative manner, but you have to have some reasonable knowledge of how it is done yourself. And you need to be able to do it by hand, as they do in DNA, if you had to. You've got to talk about how these statistics are developed, why they were developed, and how to express them. All right, but there's more, and I'm almost to the end so we can get to lunch. There are constitutional considerations. And this issue is a recent issue because of the various cases that have come down with respect to the admissibility, particularly of lab reports. Bullcoming, Williams, the Crawford case, early Crawford case, all talking about the Sixth Amendment right of the defendant to cross-examine testimonial evidence. And so the issue in all these cases is, what is testimonial? All right, so in two cases, the two cases you see here, the defense objected to the expert testifying about the statistics that were computed by the FBI's computer or computed based upon an article in the Journal of Forensic Science, a database showing up there, because that is testimonial evidence that was not personally conducted. The analysis was not personally conducted by the examiner. So it's a Sixth Amendment issue. Both of these courts, fortunately, found ways around describing that portion of the testimony, that is, with respect to the quantitative analysis, as being testimonial in nature. However, you're going to have to expect that objection, particularly now since the roadmap on the Sixth Amendment after these cases, Melendez, Diaz, Bullcoming, Williams, and Crawford, is so messy, squishy, mushy. And so you need to be prepared when you testify on those issues that you know something about it. There are ways around it. I think any objection on hearsay will be thrown out. That oftentimes it would be sustained because this is information that an expert would normally rely upon in developing their opinion. There are ways around it, but you need to talk to the prosecutor, know the jurisdiction that you're in. So these are the endnotes. I can read them all to you, but I don't think you want me to. But that's a very quick rendition of what I think is the likelihood, and I think it's good. That's a qualitative term based upon a scale that I have that has 25 different gradations. So I think it's good if you work as assiduously as you are now that you will be able to get that evidence in the future. Thank you very much.
Thank you, Ken. We do have a few minutes for questions if anyone would like to ask a question of Mr. Melson.
By the way, lawyers are that half of the population that don't know anything about statistics? Or, yes, ma'am.
You stated you added a new case, and I think you said State versus Garrison, and you
Yes.
gave a 535 or 585. I didn't get that number, and I'd like the reference, please.
Okay. Can you post the new one?
Ken, we'll go ahead and get our public affairs to post the new version of the talk on the on the conference website.
It's up there.
To take care of that.
And if you look at the cases on the constitutional issue, you'll find the sites if you want to read Crawford, Bullcoming. They're just too long to put in there.
Mr. Melson.
Yes, ma'am.
Now, with the NAS report, it really bothers me that a document examiner was not part of that panel to make a presentation and present our literature. What were they thinking?
Well, I don't know what their thinking was at that particular point. There are several objections I had to Chapter 5. One was that they didn't have experts in every field testify about the disciplines that they were commenting on. Number two, the PowerPoints that were used and the presentations were very superficial in most regards because they only had a finite amount of time for their public hearings. The third thing was that I asked Anne Marie Mazda, who was the principal investigator or coordinator for that, to divulge what personal investigation and research the individuals of the committee did, because if you read the report, it says after hearing these, they did their own research, and this is what they came up with. I thought that since this was publicly funded, we ought to know what that research was that they looked at, for instance, in handwriting, because it wasn't in the public record. The only thing they were willing to put on the public record were the public presentations. The behind-the-scenes research that they relied on, I don't know what it is. It would have been nice to know, because then we could evaluate some of that.
On that same issue, I was going to address it. I served on the National Academy Committee, and it was a large committee, about 30-plus people. And, of course, I had some background in question documents. But it was hard for me to get them to put a question document examiner to testify in front of the committee. And the final statement that you put up there, that there may be some value, I mean, I had to argue for it quite a bit to even put that one in. It was not going to be there. I mean, this is the deliberation that happened there. But there are references in the National Academy of Sciences report for computerized processing, and one of my publications or something like that is referred to in that. So, in a sense, the committee was negatively inclined towards putting question document examination, and there was no testimony given. And finally, something appeared in it. So that's the history of it.
Good. Well, thank you for fighting for some value.
That's all I was able to get in.
Ken, this may be hearsay, but
Okay.
I did attend a few of the committee meetings. Obviously not on the committee, but I did attend a few of the meetings. And I specifically asked the question of one of the co-chairs, why handwriting examination or other question documents was not put before the committee. And I was told specifically that there was not time to investigate every forensic discipline, and handwriting comparison was the same as latent prints, and so they did not need to have the duplication. So I disagreed with that philosophy, but I can understand there were time limitations, and they understood that they had to limit the scope of the work. So I think that was primarily the issue.
Good.
Then why did they comment on question documents if they did not do the research and did not hear from any
I was gonna ask you
document
that, but-
examiners? It's astonishing, actually.
Yeah. It would not have passed a Dahlberg hearing.
Any other questions? Okay. Thank you so much, Ken.
You're welcome.
We really appreciate it.